If I may ask Raza Rabbani Saab, given the topic, given the subject, which is the need for a constitutional court, for him to give some opening remarks. I can preface it with some background, which is that in 2006, when the Charter of Democracy, a key moment in Pakistan's history, particularly recent democratic history, happened, and Raza Saab was an instrumental figure in that process. For the first time in recent history, we saw the demand that there needs to be a separate constitutional court. So a bifurcation between the functions of the Supreme Court as it functions as an appellate court, as a court hearing regular cases in a constitutional court. And we'll sort of, if Raza Saab in his remarks can also reflect on that and what has happened since. So I'll ask Raza Saab to open with his remarks. So we can.
First of all, speakers sitting on the podium, the distinguished Minister for Law, ladies and gentlemen, and my dear students. I was told that this is to be more of a conversation, and therefore I have tried to limit myself to a written text so that I don't go on rambling, and that we can have more of a question and answer and a conversation amongst ourselves. As far as the topic is concerned, I have always found that an engagement with the Constitution of Pakistan, 1973, is like being in love. And that is for the simple fact that there is never a moment without anxiety. The Constitutional Court, as you all know, is an exercise is a special court that exercises only the power of constitutional review. The system was introduced by the Austrian scholar Hans Kelsen and is founded in the European states such as Austria, Germany, Italy, Spain, and its influence has also carried to Colombia, Russia, the Republic of Korea, Turkey, and Taiwan. The motivation in establishing the Constitutional Court is to create a strong and specialized judicial type of a body capable of enforcing a new constitution or a new constitutional deal. What is more important is that the court is also empowered to decide on abstract questions. For example, it may have the power to examine the constitutionality of a law even before it is passed by Parliament. And I would like to lay emphasis particularly on this issue. The following and collectively are the powers that may be exercised by a constitutional court. Number one, constitutional drafting jurisdiction, that is, controlling the Constitution itself. Number two, judicial review of legislative acts, controlling the legislature. Number three, jurisdiction over officials and agencies, controlling the executive. Number four, jurisdiction over political parties and elections, controlling elections. It is not simpliciter, a court that adjudicates on constitutional disputes, but has wide-ranging implications. A reference was made to the Charter of Democracy, and yes, it is a fact that in the Charter of Democracy, it was stated that a constitutional court would come into existence. But then at the time, when we were drafting the 18th Amendment, and which was an extensive period of time, something like over 9 months, during that period, an extensive discussion was held on whether a constitutional court, as envisaged by the Charter of Democracy, was needed or not. And we came to the conclusion at that time that at least for the moment, a constitutional court was not needed. And the reason for that being the complexity of the powers that are flowing from a constitutional court. Number two, an additional structure was to be added to the federal judiciary, with already the Federal Shariat Court and the Supreme Court. It was in our mind to do away with the Federal Shariat Court. But unfortunately, because we didn't have the numbers in terms of a 2/3 majority, without the religious right supporting us, and then they brought in question the entire 18th Amendment, had any of the Islamic provisions in the Constitution be touched. Therefore, we were compelled to continue with the present structure. Number three was the volume of work. It is today that one finds that there is a spat of constitutional issues that are being raised in courts. But in normal course, if governments are running according to the Constitution, and if the system is functioning, then the quantum of work would not justify a court. The other issue that was taken up at that time was that we recommended that in the Supreme Court itself, there should be a constitutional bench which would look at constitutional issues. But having said that, I think what one needs to do is to look at the Constitution itself. Because the Constitution itself of 1973 provides for a number of solutions to various issues that arise between the federal government and the provinces, between the provinces and the federal government. And one would then be questioning the fact that if one was to look at the Constitution and one was to follow the Constitution, would litigation in that stricto sensu terms really be necessary? Let me give you some of the examples. For example, if you look at Article 152 of the Constitution, which deals with acquisition of land, if there is a dispute that arises between the federal and the provincial government, the Chief Justice of Pakistan is to appoint an arbiter. Number two, if you look at Articles 153 and 154 of the Constitution, you have the Council of Common Interest, and that in which a provincial and the federal government are represented. And if there is a dispute, or if one of the parties, that is the federal government or the provincial government, is not in agreement with the decision of the Council of Common Interest, then it can take that decision to a joint sitting of Parliament, whose decision would be final. Similarly, if you look at Article 157 of the Constitution, which deals with electricity, and should a dispute arise between the federal government and the provinces, it is to be referred to the Council of Common Interest. Similarly, Article 156 of the Constitution, priority of requirements of natural gas. This matter, in any case, falls within the domain of the Council of Common Interest. Article 159 of the Constitution, broadcasting and telecasting. In case of a dispute between the federal and the provincial governments, the Chief Justice is again to appoint an arbiter. But here we have moved an amendment in the Senate that since it is a matter which concerns the Federation, therefore instead of the Chief Justice, it should be the Senate which appoints the arbiter. So that amendment is still pending. Article 161 of the Constitution, it deals with natural gas and hydroelectric power. The article provides that the net profits are to be calculated on a formula which is to be determined by the Council of Common Interest. In Article 184 of the Constitution, 1973, the original jurisdiction of the Supreme Court deals with disputes between two governments. Article 186 of the Constitution, the executive may refer a question in the advisory jurisdiction of the Supreme Court. But having said that, and why have I gone to taxing you and walking you through the Constitution? I have to say with a great deal of respect and with a heavy heart that since 1947 till today, there has been a historical nexus in the power equation between Pakistan's establishment and the judiciary. This power equation, which is dominated by Pakistan's establishment, at convenience picks up stakeholders to join them in perpetuating their power, to join them in the exploitation of the resources of the provinces. And therefore we have found that at different times, military takeovers have been given a legal cover. We have found that after the military takeover is over, yes, you may have a judgment calling a person a usurper. But at the nick of the time, they have been justified under the doctrine of political necessity. We have also found that there have been times when the military dictatorship has not asked for the powers to amend the Constitution, but those powers have been given, regardless of their asking to amend the Constitution. But as time has gone on and the military dictators have found that it is more convenient, rather than abrogating the Constitution, because they are aware of the fact that the 73 Constitution is such a document for which a national consensus amongst the federating units and amongst the stakeholders may not be possible. So therefore we have had new terms, the Constitution being held in abeyance, certain articles of the Constitution being suspended, and now we have a new doctrine. And that new doctrine is the doctrine of reading in. And in the doctrine of reading in, we find that regardless of the fact that in the Aam Log Ittihad Party case, which is PLD probably 2022, regardless of the difficult test that the court itself has laid down. But yet, when it comes to giving a push, that test is thrown to the winds. And you have the doctrine of reading in, and now I was really taken aback. In fact, as a member of parliament, I was thinking as to whether there is any need of parliament now or not, particularly after I went through the detailed reasoning in the presidential reference on Article 63A of the Constitution. The manner in which the doctrine of reading in has been justified, quoting foreign jurisdictions, in particular that of the United States. But what we must realize is that there is a vast difference between the United States and the ground situation in Pakistan. Essentially, the United States has a presidential form of government. Pakistan has a parliamentary form of government, or at least that is what we hope it will have. But having said that, why I have changed my mind is because of the nexus, because of the obtaining objective conditions. What in actual fact is needed is for all of us, including myself, and I include myself as number one. What is needed is a change in the mindset. Until and unless we change our mindset, we can have no matter what type of legislation, but it will end up at naught. You can have no matter what type of courts, but if the mindset continues to be the same, then the net result would also be the same. In conclusion, I would just like to say this much, that I believe, and the Constitution so provides, that Pakistan is a federation. And after the 18th Amendment, Pakistan has become a participatory federalism. And in a participatory federalism, I think what needs to be done is we need to go back. We need to go back to the Government of India Act 1935, when the Supreme Court was known as the Federal Court. I think it would not be a bad idea, if the Law Minister is here, if it would now once again, keeping in view the federal character of the state, if it was to be called as the Federal Court. And while calling it a Federal Court, I would also stress that being a federation, we must keep in mind that there is representation, if not equal, but then there is representation on the bench in terms of the provinces. We must also bear in mind that while keeping this one issue of the provinces in mind, the criteria must also be laid down to the appointment of judges, in which seniority should be paramount. And I think that once there is a change in the mindset, then of course one can revisit the question, according to me, of whether a constitutional court is required or not. Thank you very much.